In high net worth divorces, just as in any divorce, the first way we're going to evaluate the assets is we're going to disclose what we call our preliminary declarations of disclosures. Both parties are required by law to disclose all of the assets that they have, whether they believe them to be community or separate. The next step is, once we have those disclosures and know what we're dealing with, is a lot of times when we have high net worth assets to value, we're going to use evaluators and professionals to value those assets. We might get an appraisal of a home. We might have an independent business evaluation done. If the parties are working well together, we can get what we call a 730 expert in order to have a joint expert to reduce the litigation and animosity in the case as well, so that both parties are working together on valuing those assets. If there's a business, similarly, we can also value that business using a business evaluation or appraisal. And most often we're going to do this at the date of separation. In high net worth divorces, we often deal with restricted stock units. They are different than stock options in that they're going to be guaranteed, but guaranteed at a certain time or upon a certain condition being met. The most simplest issue is going to be when we have a marriage where one party or both parties were given stocks that were vested during the marriage. In that case, the presumption is that they are community property and they are going to need to be divided and subject to the divorce. Once everything is evaluated, the next step is that the property will be allocated. And that can be done either by agreement, if the parties agree to allocate property in a certain way. But the standard and the default is going to be by law that these assets, if they are community, are going to be divided equally. That can be an equal division by a court order or by agreement. There's also an option that if the parties agree to a different allocation of property, then we can agree that one asset is allocated to one party and another asset to another, rather than dividing equally. So an example of that would be, let's say that the community has an interest in a residential property, but at the same time, one of the parties have a restricted stock units or a business that they have an interest in, and they would like to keep that business. A perfect example would be one party keeping the house and the other party keeping their business in full, or offsetting that in some way. The best way to safeguard your assets in a divorce is to do so preemptively. I always recommend that clients, when they're considering marriage, that they meet with an attorney and come to our office and meet with us to consider a prenuptial agreement. There's also an opportunity after you're married to enter into a postnuptial agreement, which can offset the default community property rules and protect your assets coming into a marriage. Another consideration is you can have the assets valued at the time of marriage, so you know what you are coming into, especially important if you have a business that you're entering the marriage with. If you have an extraordinarily high income, because that income is so much higher than the norm, that it can be taken into account to limit spousal support, and that's something that we can help with. Alternatively, if the other party who is going to be supported has access to a significant amount of assets, that can also be taken into consideration as their needs are being met, and we can help limit support in that regard. So a prenuptial agreement, or a prenup, that is going to be a contract that two people enter into in contemplation of marriage. And the prenuptial agreement is often done to protect assets, or whether they're existing or future assets that they anticipate could come into play. There's also support that can be taken into consideration. Now, this is when parties most likely want to go away from the default, which is the community property laws. A postnuptial agreement is similar. It's just going to be entered into after the date of marriage and before contemplation of divorce. If you have any questions about high net worth divorce, you can call Fenchel Family Law.